am a lawyer, but I am not necessarily your lawyer. The materials discussed in this podcast are for informational purposes only and should not be deemed legal advice. If you have a specific legal question according to your circumstances, then I encourage you to speak with an attorney licensed in your jurisdiction. Welcome back to another edition of Ag Law Today. We've got Julie Fershtman back in the house, and we're talking about Equine Activity Liability Acts. Julie, welcome back.
Thank you for having me. Good to be back.
So, Julie, why don't you remind our listeners, who are you, where are you, and what do you do?
I'm an attorney. My practice is in Michigan. I'm a shareholder with a firm called Foster, Swift, Collins, and Smith. But information on me is easily found by equinelaw.net, and that's equinelaw, all one word, .net. But in 34 years of experience, my practice has involved business litigation, insurance law, which includes coverage, lots of liability defense. On liability matters involving livestock, I tend to represent the business or animal owner, not the plaintiff. And a good part of my practice involves horse-related law.
So, Julie, I'm curious, what made you want to? Yes, tell us about your book.
It just came out last year. The American Bar Association published it. It's called Equine Law and Horse Sense, using the title from my first two books published in the 90s, well, 96 and 2000. But it just came out last year. It's on Amazon.
Yes, and I've read the first two, and they are outstanding. So I just want to commend you for that. So I can't wait to pick up the copy for the third book. And you said that it's available with the American Bar Association. Is that right?
That's either the ABA for people who are listening, who are members of the American Bar Association, or on Amazon.com. Just look up Equine Law and Horse Sense. Look for the book with the horse on the cover, and Amazon might very well be discounting it.
So, Julie, I'm curious, what made you want to go into equine law? Do you have a horse background yourself?
I do. This is what happens when you get old like me, but many, many years ago, probably about 50 years ago, to be more specific, living in the city, I started doing pony rides as a young kid. And then going further, I began taking lessons, starting to ride, and owned a few horses. But never did I think back in the 90s when I started this that you could merge horses and the law. And back then, as you know, well, you don't know, you're younger than me, but we didn't have the internet in the early 90s for people like me to access information. And so I made it my life's plan, my passion actually, to spend weekends in law libraries, researching, reading, and finding anything I could get my hands on dealing with horses and law, which led to a series of articles. I now have about 400 of them, and then my books. And I've got 4 books dealing in some respect with horse law. So the interest in horses fueled the interest in horse-related law, and I'm hoping it encourages lawyers to merge interests with their law practice too.
That's fantastic. So talk to us about the Equine Activity Liability Act. I feel like I need to say that 3 times really quickly for the tongue twister, but tell us about this statute. What is it? What does it do?
One of the things that I pretty quickly learned when I began doing the research back in the early 90s was a trend. And the trend was that beginning in 1989, states began passing laws about liabilities relating to horses. State of Washington was the first up, and then Colorado, and then others. And now by the mid-90s, more and more states were climbing aboard and developing their own statute. The equine liability laws, and some are now farm animal activity liability laws, are now in 48 states, all states but California and Maryland. And these laws are designed to limit or control in some way liabilities where livestock and horses are involved. Quick thought before we run to another question. The state of Texas is one example of a state that began with an equine liability law, but broadened it out to become a Farm Animal Activity Liability Act. And the laws changed, the sign requirements changed, Other states have done similar things. So these laws, which were equine at first, in some states are much broader than that now.
So the two states that you mentioned, California and Maryland, that don't have this statute, do you think that horse owners or livestock owners are more likely to be sued in those states?
Well, it's possible. Even in states with equine liability laws, as we can discuss, litigation is certainly possible. And we can talk about the exceptions that allow people to sue. But people have asked in the states of California and Maryland, do we have a bad rap? Are we worse off if our state doesn't have one of these laws? And the answer is, if you ask some people, including lawyers out there, they'll say we're not so bad off. And this is why. California has a very robust body of law called assumption of risk, where if you can prove that the person injured understood what they were getting into and the injury was related to the kind of risks that should have been understood, they may take nothing. And there are plenty of examples in the state of California of cases that have been thrown out against providers of horses and horse activities because of the belief that the person hurt, well, they should have assumed that risk. So the robust body of law in California leads some to believe that maybe they don't need an equine activity liability law. Well, that may be true. The flip side of it on California is the understanding of what is an assumed risk and who should assume that risk can get very case specific, and it may be hard to predict how the rulings are going to go. So it's a mixed bag in California, but plenty of people think we're not doing too bad. Shifting to Maryland, lawyers over there will tell you that they're one of few states in the country that have a pretty robust, well, not even robust, they have a principle of contributory negligence, showing that if you are defending a personal injury lawsuit in the state of Maryland, and you can prove that the person suing is even 1% responsible, my understanding is in the state of Maryland, that injured person gets nothing. They take nothing. They like that then in the state of Maryland, and there has been a lot of pushback when discussion has occurred about equine liability laws there. Again, very few states have contributory negligence as the state of Maryland does. So they're pretty happy with how they're doing. The flip side on that, though, you still have to prove that the injured person bore some responsibility. That can be doable. It may not be doable when you have a complete novice in an equine activity. So it's still a legal expense waiting to be paid. But those states are the only two with no statute.
So, Julie, I've heard people say that this is a zero liability law. I mean, what are your thoughts on that? Is there such a thing?
I think that people who are injured wouldn't want a law like that, because I think we'd all agree that the law should allow, in certain circumstances, recourse. The question is when we should shut that recourse down. And so these laws are not zero liability laws. And it shocks me when people say that, because it's not true. And I'll explain why in a moment. Some people have been known, if their state has a law and they learn about it, to cancel their liability insurance. Clearly, that is an unwise move, because these laws don't apply to everything. For example, equine liability laws generally only apply based on the typical trend in how they're worded when a person has engaged in an equine activity. Okay, but some things don't quite trigger that engaging in an equine activity. Now what? Well, the law may not apply, and anybody who cancels their coverage may have a problem. But the other thing I'd like to share with you that we kind of touched on is that these laws are not zero liability laws because they specifically provide in the common form that most states adhere to. There are differences. Virginia has a different law than many others. Arizona's is very different from the others. Connecticut's is one paragraph, much different. But many of the states follow a pattern, and the typical pattern provides that there are exceptions that people can sue for. One is faulty tacker equipment. You provide a horse and you knew or you should have known that the tack or equipment that you provide with the horse was faulty, and that fault or problem causes injury, death, or damage. You can have a lawsuit. So you can imagine cases involving the girth, that is to say for non-horse people, the equivalent of a belt that holds the saddle on. If there's a problem with that, Some cases have looked at faulty adjustments, some have looked at broken buckles, but if there's a problem with it, there may be an issue here under faulty tacker equipment. The number 2 exception that generates most of the lawsuits under equine liability laws is one that is the reasonable and prudent efforts exception. Briefly, it states under most laws, if you provide an equine and you fail to make reasonable and prudent efforts to determine the ability of the participant to safely manage the equine, you might be liable. That exception is applied typically to cases involving horses given to others for lessons, the riding instructor liability cases, where the student falls off because the horse wasn't suitable, perhaps for a novice rider. The horse was more suitable for a highly experienced rider who could control it better. That is your classic case, but there are a lot of other ones that fit within that exception. Third exception is the dangerous latent condition of the land one. It generally reads, if you own, lease, rent, or are in lawful possession of land or facilities with a dangerous latent condition, which is to say non-obvious, for which you have failed to post a noticeable warning sign, you could be liable. Now we're dealing with land. There have been some cases on that, but not a lot of them around the country. Fourth exception is intentional wrongdoing. And Cari, you know that no insurance will insure you for an intentional act. So what you see with litigation involving these equine liability laws, well, what you don't see is you don't see cases raising the intentional misconduct exception, because lawyers who sue, who want to collect money, don't want to trigger no coverage. But that is an exception. 2 more. A lot of the states have exceptions for gross negligence, willful, and wanton misconduct, which is generally speaking an elevated degree of negligence, not merely inadvertently doing something wrong, but doing something wrong when you really should have been unaware of a problem. Different states evaluate it differently, but the last exception, which is only found in a small number of states, is one for negligence. And as we know, Cari, negligence is failing to do what reasonable people should do or doing what reasonable people don't do. It's because of the open-ended understanding or definition of negligence that, frankly, these laws got passed. Because you could think of a lot of different things with horses and livestock that you would consider negligent. And the question is, what is a typical risk and what is crossing the line to negligence? It's that uncertainty that frankly has fueled litigation, and it was that uncertainty that got these laws passed. But yet some states have negligence exceptions.
So Julie, I'm curious, what are your biggest piece of advice for your clients on to prevent an issue from happening? Let's just assume they live in one of the 48 states that have this type of statute.
Sure. Here's what I recommend to people to be a step ahead and to avoid liability. First, of course, make sure you have proper liability insurance. I think that's a must. And we're not talking mortality insurance, as you and I have discussed before. We're talking coverage against some sort of activity that causes a person to be injured. Make sure you have the right insurance. So let's say, Cari, you decided let's say you want to be a riding instructor. You don't have insurance for business in the horse or animal industry. Actually, you might, but we'll put that aside. If you are just an average animal or horse owner and you decide to become a professional, you may not have business insurance. First and foremost, make sure you have proper liability insurance, which would include business coverage if you have a business activity. Second, make sure you have signage posted. Most of these equine statutes have a requirement that you need to post a warning sign, sometimes several, and the laws will tell you what goes into it, how big the letters need to be, sometimes what color the letters need to be, and where you need to put them. Sometimes they're specific, sometimes not, but post those warning signs. Some have even asked, well, who posts them? Who's required? Most of the laws put the burden on professionals and sponsors, not the average Joe necessarily. I say put up the signs anyhow. Why not? The next one, many of these laws require contract language. If you use contracts, we'll talk about waivers in a moment, they want you under many of these laws to include certain language. Sometimes it's inherent risk language. The state of Ohio, for example, in its equine statute, wants a whole list of inherent risks put in your contracts for certain people. Put the language in if it's required. Some states require a warning notice, much like on the sign. Some states require both. Years ago, Iowa, I believe, required both a list of risks and the warning notice, which they also require for signs. Comply with that contract language requirement. Next is consider using waivers and releases. But as you know, Cari, that's a whole different discussion in and of itself, because they don't always apply to a situation. Some states will not let parents release claims of their minor children. Some claims, like willful and wanton misconduct, gross negligence, intentional wrongdoing, well, you just can't release them away. But to the extent that you are in a state or do business in a state that is willing to enforce waivers and releases, absolutely use them. And to put it very brief, because we could talk for hours on waivers, make sure that whatever form you're using complies with the law of the applicable state. People, as you know, in the industry, agricultural and equine industry, they'll go online, they'll get a form if they're in Maine from California, but California doesn't necessarily require the same language as other states. Use a waiver that complies with your state law. These are the typical suggestions that I give to people. Finally, of course, just good, basic common sense. You know, if you are engaged in horse-related activity and you have an equine liability law, you might be liable if you provide faulty tacker equipment. Well, check your equipment before you give it to someone. Western bridles sometimes have those screws. They call them Chicago screws, referencing Chicago, which is not far from, well, you're in Illinois. Why not double check and make sure that those screws are properly tightened? Some would say put Loctite in them or nail polish in them and then screw it in so that it gives an extra layer of protection and holds things. Check your equipment before you use it, or rather let someone else use it. Use common sense.
So Julie, to close, it's my understanding that the very first Equine Activity Liability Act came into place in the state of Washington many years ago, in approximately 1989, if I'm not mistaken. Are all the states pretty similar with their Equine Activity Liability Act, or there are a lot of differences from jurisdiction to jurisdiction?
The differences are there, jurisdiction to jurisdiction, and it's fascinating when you look at a couple of them. If anybody is trying to figure out what is she talking about, I believe I touched on briefly, and I'll emphasize it now. Some states that really are in a league of their own would be, for example, the state of Arizona. Its law applies when a person takes control of an equine. It requires that somebody sign a waiver. It gives you some ideas of what goes into the waiver. That's not typical for an equine liability law. The state of Virginia refers to intrinsic risks of equine activities, whereas most other states, in fact, just about all, talk about inherent risks, but it's even deeper than that in Virginia. Virginia requires a document with certain language. I mentioned briefly about the state of Connecticut. Its statute is all of one paragraph. It is nowhere near as complete as the others. New York's now is different. It's more of an agricultural liability statute that can be extended to equines. They all differ tremendously.
So Julie, if one of our listeners is looking for an agriculture attorney or an equine lawyer, and they're in a consultation and they're perhaps asking questions about the topic at hand today or another equine related issue, what's your general advice for that person? Are there specific questions that they should ask in that consultation to make sure that they're a right fit?
Well, there are. Picking a lawyer for any matter, whether it's an equine, agricultural, or any matter, it isn't easy. On the plus side, as you can tell, we have search engines at our disposal. Turn on your computer, link it up to the web, and we have ways of putting words in and finding lots of names. With that, we can look at websites and get biographicals, but sometimes it's the personality, as you know. In litigation, for example, the personality of that lawyer may be everything to you. If you are the one with a lawsuit, you believe you've been defrauded, and you want to really show that other side, well, you may want, just for your own purposes, a lawyer who is heavy-handed and tough and mean. A lot of people just have that reaction. But then there's the other approach, which you can only really get from talking to that lawyer. And that is, you may want a lawyer who is well regarded in the jurisdiction, level-headed, but very experienced, so that that lawyer can be the voice of reason that will be received well from that judge and may very well give you a better chance at getting whatever your goals are achieved. So the personality of the lawyer can mean a lot, especially in litigation. Sometimes I've said to people, having a young lawyer who might be less expensive could be perfect, because he or she may want to learn more about your matter, may not even bill his or her time at a high rate, and will work extremely hard. You'll have to be the judge of that, because with that younger lawyer comes the learning curve on the subject matter and, frankly, the ins and outs of a legal proceeding. Finally, if the matter is a contract, I think you'd agree, you may want a lawyer who's done plenty of these before. Me, for example, I've done so many contracts that I do them on a flat fee basis. I don't just push a button and send it to a client, but I know the right questions to ask and I know how to customize these things. There's an efficiency built in. So if it's a contract, understand that a less experienced lawyer might very well charge more, because it's going to take him or her more time to get the job done.
Yeah, that's why the hourly rate is so deceiving, because I think sometimes more experienced attorneys that bill at a higher hourly rate can actually be cheaper, in the long run. So it's very challenging for a consumer to navigate with all of that. And yeah, I can't agree with you more. I think that there's a lot of choices in the market, and different choices for a reason. So Julie, where can our listeners find you? Do you have any contact information?
Well, the easiest way for me to be found is my website, which is www.equinelaw.net. That has a little information about my practice and what I do. Even though I've tried cases in 4 states, and even though I've worked on cases in 18 different jurisdictions around the country, clearly, as you know, and some people don't, lawyers like you and me, we can't just go jumping into a state where we're not licensed. So we can work around the country, but we do need to comply with state requirements, which often means having a local attorney involved in some way. So for me, and probably for you too, I've been hired to draft contracts for people all over, but their local attorney gives it a final approval and they're good to go. In a litigated matter, lawyers like me can be a consultant to work with a person who has a lawyer to help them maybe do a better job on the case to the extent that we can help, but they still need their local lawyer if it's out of state. And just like I'm sure you as well, if you've litigated, I can litigate around the country too, but people will need a local lawyer. So obviously the point is, we can't just step in all over the country, but we certainly are available to work as we're allowed to ethically.
Yeah, no, absolutely. Well, thank you, Julie. I really appreciate you coming back to the podcast.
Thank you.